Okay, thank you. Good afternoon. Good afternoon. Good evening. Good morning, wherever you may be watching us. Welcome to Dr. Olu Asekun podcast. Thank you for joining. Please invite your friends, family, colleagues, and join us as we start this week's edition of the podcast. As usual, we'll talk about few updates and then go into questions and answers. Please bear with me because I don't mind, please. That's why I removed my tie. Thank you for joining us as usual. Invite your friends, family, colleagues, and join us. As we proceed today. So, not much happened between last week and now, but we still have a couple of updates. So how do I use it? Okay, thank you. As in spray it. Oh. Thank you. Not much happened between last week and now, but we still have a couple of updates. You see, at the beginning of this administration, for those who have been following our podcast for some time now, you realize that the government, this administration, they have been terminating the employment of a lot of immigration judges. They even dismissed some judges from the Board of Immigration Appeal. But now, to my surprise, they started hiring new immigration judges. And I know what is going on here. This is an ideology replacement. They were removing those judges that they believe that are liberal, and they are replacing them now with judges that probably will dance to their tune. So, the EOIR, Executive Office of Immigration Review, that is the body that regulates the immigration judges, they announced the appointment of 42 new immigration judges. You and I know what this means without having to explain further. You know what it means? I mean, if you really know you need immigration judges, why remove those who are already there as judges? It is very simple. Ideological change. So they are hiring and putting in new judges that will follow whatever master plan they have. So 42 new immigration judges were announced. Of course, they will join immigration courts in California, Colorado, Florida, Georgia, Illinois, Louisiana, Maryland, Missouri, Nebraska, New Jersey, New York, North Carolina, Pennsylvania, Tennessee, Texas, and Virginia. I also want to say that a federal judge actually stopped the termination of TPS for Somalia. the administration, the DHS, had planned to terminate TPS for Somalia, but a federal judge stopped it. So following the order of the court, USCIS has now announced the extension of the employment authorization for TPS holders from Somalia. So, based on the court order, USCIS has now decided to comply with the court order. So they have now extended the employment authorization for TPS holders from Somalia. I think was scheduled to expire March of this year, maybe March 23rd or something in that area, on or about March 23rd. But with this court order, USCIS has now announced that they will extend employment authorization for citizens of Somalia who are granted temporary protected status, TPS. Now, under the new, following the court order, USCIS announced that the validity of employment authorization issued under the TPS designation of Somalia with an original expiration date of March 17, 2026 is now extended by the court order. So if you are from Somalia and you have a TPS and your employment authorization has either expired or is about to expire, or you need to renew the employment authorization based on the TPS, following this court order, this is the instruction you need to follow according to USCIS. When completing the expiration date, if you are trying to get an employment and you need to complete Form I-9 based on this extension, if you need to complete Form I-9 based on this extension, the instruction from USCIS is that on the Form I-9, in the input where they ask your status, you indicate as per court order. As per court order. That should be Section 1 of the Employment Authorization Application Form I-765. So if you are in that category, so on that Section 1, you write there the basis of your employment authorization, you put as per court order. Then you also add March 31st, 2026 in Section 1. And in Section 2, Section 1, that's why you put as per court order. Section 2, that's why you write March 31st, 2026 in Section 2, along with a note in the additional information box. Usually at the end of the employment authorization form, you see additional information. So you put a note there that as per court order. Now, USCIS has also instructed employers to download TPS Somalia webpage on their webpage and attach them to Form I-9 so as to not be liable for purportedly hiring somebody without valid employment authorization. So they should download the TPS Somalia webpage and attach them to Form I-9. And also, when completing a case in E-Verify, I believe this should be employers now because I don't believe employees have access to E-Verify. But the employers, they should enter the expiration date of March 31st, 2026 on the Form I-9. So that is the instruction for those who are affected by the court order extending the TPS for citizens of Somalia. Now, as you probably already can see, I'm not feeling too good, so we are going to probably be spending 1 hour on today's program. So let's go into questions. As I said, not a whole lot changed from last week and now. So let's go into questions and answers, please. Okay, first question. Good day, sir. God bless you and your team for all you do for us. Amen. Sir, my son's EAD has error of date of birth and was returned. No response since 2024. It got expired and I sent the renewal. I have received notice. And number 2, and 540 days extension since last year. I've not gotten the physical card. This error is affecting his college application because the age document does not tally with the school record and immigration record. Sir, is it advisable to seek congressional help because this is urgent for his admission? And my country, Nigeria, is part of the bank country. Will there be any issue going through the congressman? No, there can't be any issue. In actual fact, that's about the only thing that I can suggest. You do a service request. Ordinarily, the ban should not affect this because it was already approved. However, because the one that was approved is expired, the ban may affect the issuance of a new one. But I will still suggest that you go online, do a service request. Even if they respond and they tell you that the application is being processed or the travel ban affected it, which they may do, you can still attach that to the college application and show evidence that you have a pending case. But you can still try the congressional intervention. I believe that they may still be able to do something about it because this should not be treated as a new application. So you can go ahead and do the congressional intervention. Even if it does not work, you have nothing to lose. It doesn't change anything. So I would still suggest that you go ahead and do that. This is one of the frustrations with this administration, why we don't really know how to address issues like this, because this was clearly an error from them, and yet they are not correcting it easily. But you can go ahead and do the congressional intervention. Next question, please. I didn't see a question.
Good afternoon, sir. And then I will play.
Oh, okay. Good afternoon, sir. Okay. Please, how can I check my immigration record with USCIS? I'm an asylee who entered the US legally.
And then he sent this other question here. The last one.
How can I do a service request from USCIS? Well, service request cannot give you access to your record. If you need access to your record with USCIS, you have to do FOIA. That is different from service request. You have to do FOIA. FOIA is Freedom of Information Request. That is, you are requesting for copies of your file, copies of everything you have on your file. Now, FOIA can be done with multiple agencies, so you have to be sure exactly what you want. Because if, for example, you want embassy record, if you apply for FOIA with USCIS, you will not get it. In that situation, you have to apply for FOIA with the Department of State. if you are in removal proceedings and you want copies of your record, you cannot apply for FOIA with USCIS. You will have to apply for FOIA with the EOIR. That is the Immigration Court. However, if your case is affirmative, you have a pending case with USCIS, you are not in removal proceedings, you can apply for FOIA with the USCIS. And of course, if the information you need has something to do with your entry into the US, then you apply for FOIA with CBP, Custom and Border Protection. So you have to know exactly what you want so that you don't waste valuable time with the FOIA. Because if you apply at the wrong place, by the time you get the response, you realize that is not what you want. So that is the process. I believe there is a form for it. If you want to do it yourself, there's a form for it, FOIA form. So you complete the form, you provide proof of identity. They have to know who is applying. So if you have valid ID, you attach it.
You can only do it online now.
Okay. If not, you attach copies of the biometric page of your passport. And I understand that you can only apply for FOIA online now. It can no longer be physical letter. It has to be done online. So you scan your identity document. So once you submit the form, you upload the identity document. And of course, you provide identifying information, your name, date of birth, country of citizenship, entry date, and all of that. So you provide identity information, and then you should be able to get it as quickly. It depends if your case is electronic. If you have electronic file, you should get a response within 30 days. But if your file is paper file, it may take longer because USCIS will need to scan your file first before they can respond to your FOIA request. Next question, please. I filed for VAWA with work authorization December 2022. Got request for more evidence in April 2023, but I'm yet to receive anything on work authorization and no progress on VAWA 2. Any suggestion? Well, until VAWA is approved, employment authorization is usually not associated with VAWA. So if you need employment authorization, you have to apply separately. And for you to apply for employment authorization, again, that is not associated with VAWA. You have to submit I-485, application for adjustment of status. So employment authorization is only associated with a pending application for employment authorization. So if all you have pending is just your VAWA, which is the I-360, you will not get employment authorization until the VAWA is approved. So if you want employment authorization, you have to file I-485 and then apply for employment authorization based on the I-485, and your category will be C9, meaning that you have a pending application for employment authorization. If it is just the VAWA, you will not get it. You have to apply separately. Next question, please. Okay. God bless you and your team, sir. Amen. I have pending I-485 and 765 based on an approved EB2 NIW. My H-1B expires mid-April, and my employer has filed an extension but cannot keep me beyond fiscal year 2026, which of course will be September 30th of 2026. Okay. Another employer is offering me a 2-year postdoc rule. Considering the Nigerian restriction, what should I do if I want to switch employers now? or after fiscal year 2026. Also, if I switch with the new employer, I have to pay the 100K hiring fee. Thank you. Please go back to the first question. I think that was about EB2NIW. Okay. Because this is a case of EB2NIW, that is a self-petition. So all this H1B thing does not actually affect your petition or your application for green card, because EB2 is self-petition. So whether you change your employer or not, it has no bearing on the adjustment application that is pending, because EB2NIW is a self-petition. Having said that, the only problem here is the lack of approval of your employment authorization. Assuming that your employment authorization is approved, you will actually not need the H1B. You could have been working with your employment authorization, because right now your status is actually the I-485, because that is an immigrant intent. That is what keeps you in status right now. In your case, the I-485 did not invalidate your H1B, because H1B is one of the few exceptions to immigrant intent. So your H1B can coexist with your I-485. However, with your I-485, you need employment authorization to be able to work. So that is the only reason why you need this H1B. But going back to the question, except your employer, the new employer, except they fall into one of the few exceptions, they will need to pay the 100,000 fee, except they fall into the few exceptions. And I believe that the exceptions has to do with non-profit religious organizations that have educational institutions. Marissa, can you remind me the exceptions to the H1B 100,000? Yeah, I know that except you fall into one of the, except the new employer falls into one of the exceptions, they will need to pay the 100,000 fee. Because I believe, well, please verify, because this is an extension. I don't think it will be treated as a new application, but it's a new employer. Please verify it so that I don't mislead this person. Please verify it. While we are doing that, go to the next question.
There were 3 questions. Did you answer all 3 of them for him?
Yeah, I believe I answered all 3. You can go back to the, because like I said, the first question is about the EB2NIW, and I already answered that the adjustment application is what is keeping him in status. However, the adjustment application requires him to have employment authorization. Otherwise, he will not be able to work. So for that reason, he can still continue to work with the H1B, because H1B is one of the few exceptions to the immigrant intent. So he can coexist with adjustment of status. So he can continue to use it. So the last question now has to do with the employer, with a new employer. So the question is the new employer affected by the 100,000 fee? And I'm saying that except the new employer falls into one of the exceptions, they will have to pay the 100,000 fee. But what I want you to verify is if
the first paragraph right here. I think one of the exceptions is the employers too.
okay, existing H1B status or extensions, the fee does not apply to petitions for an extension of stay, amendment, or change of employer for beneficiaries who are already in the U.S. So that clears the answer. So the fee is not applicable even in your case. The fee is not applicable. So if you find a new employer, I believe you can go ahead and take it. Next question, please. Or go over it and make sure that I answer all three. I believe I did, but
This is the second question.
yeah, that's the one talking about the second employer.
The third one, if you have to pay the one.
Yeah,
Yeah.
it doesn't have to pay because it's already on H1B. Yeah.
So that will be the next question.
Okay, so next question. Hello, everyone. I'm glad to meet the live podcast today. Thank you. Thank you. Okay, next question.
I think you already answered this one.
Yeah, he did.
She just posted it twice.
Okay. Okay, next question. Sir, I am on F1. We soon graduate by December 2026. I am about to do EB2 NIW, but getting OPT because of the partial ban. It is difficult to get the OPT. Do you advise I apply for asylum? Well, based on this fact, you are not even eligible for asylum. It is a good thing you are asking. Otherwise, you would have applied and then find yourself in removal proceedings because you are not eligible for asylum. Number one, to be eligible for asylum, you have to apply within 1 year of entry. That is the first thing you need to know. And based on this information that you provided, at least you must have been here for at least 1 year. So you are not eligible for asylum. Secondly, asylum is only for people who have suffered persecution in the past or have a fear of future persecution by the government of their country, of their home country, or someone that the government is unwilling or unable to control on account of at least 1 out of 5 grounds: race, religion, nationality, membership in a particular social group, or political opinion. So for you to be eligible for asylum, you have to show that you have been persecuted, either you have been persecuted in the past or you have a well-founded fear of future persecution by the government of your country or by someone that the government is unwilling or unable to control. These are mandatory requirements. And of course, you must also apply within 1 year of entry. So based on these facts, you are not eligible for asylum. Next question, please. Good day. Oh, doctor, God bless you. Amen. However, prior to the end of my J1, I submitted I-485 and my university filed on my behalf H1B under premium processing since December 8. RFE response was submitted. No approval yet. Is there a continuation? Okay. With my pending I-485, EAD, and H1B, I have not been working. It is difficult to sustain a 5-member family. Please, doctor, what can I do? Can you repeat the first part of the question?
Can you file I-45 with a J1?
That's what I want to. Doctor, God bless you. However, prior to the end of my J1, I submitted I-485 and my university file on my behalf. Well, this person didn't indicate whether the J1, I'm assuming that this J1 does not have the 2-year foreign residency requirement. Or maybe this person has already applied and obtained a waiver of the 2-year foreign residency requirement. Because To start with, a J1 visa holder cannot adjust status in the US except you fall into one of the narrow exceptions. Maybe where your return to your home country will lead to your persecution. Maybe where one agency of the government in the United States has a need for your service and has requested that you do that. And in most times, you have to go to areas that are considered high unemployment or rural areas in order to meet that requirement. But since you have already filed the I-485, I'm assuming that you either fall into one of the exceptions or you have already applied and obtained a J1 visa waiver. Otherwise, the I-485 is probably going to be denied. But assuming that you have met all of these, you have been granted the waiver or you met one of the exceptions. In this scenario, honestly, the only thing I can think of is probably congressional intervention regarding your employment authorization, not regarding the adjustment. Because if you seek congressional intervention based on the adjustment, they probably will just tell you that don't even let me assume. This person didn't tell us his home country. So I don't want to even assume that this person is affected by the visa ban. But assuming that you are affected by the visa ban.
You just sent another message.
Okay.
J1 waiver already approved, NIW approved, and I-485 and EAD pending.
Okay, so great. So now that we know that the J1 visa waiver was approved, yes, that means you are now eligible for adjustment of status. So as I was explaining, even though you didn't tell us whether you are from one of the visa waiver countries, but I'm assuming, you are probably one. If you are not, I will answer the question both ways. If you are from one of the visa waiver countries, I will still advise you to seek congressional intervention, but limit it to the employment authorization only. Because if you seek congressional intervention based on the adjustment application, they will just tell you that because of the visa ban, they cannot do anything right now. But if it is based on the employment authorization, try to explain your situation to the congressman. Look, you have all this approval, you have your adjustment of status pending, you have employment authorization, and you don't want to work without authorization. You don't want to violate the immigration law, but you also need to take care of your family. So you need help in ensuring that this employment authorization is at least approved so that you will be able to work. And then whenever the government is ready to adjudicate your adjustment application, you will be willing to wait till that time. So you can explain all of these things and you can get congressional help. On the other hand, it's from Nigeria. Okay, so I don't even need to go to I was going to address that, assuming that it's not from the visa ban. So since it's from visa ban, that would be my suggestion for now. Next question. Can an incorrect no to brief unauthorized work on an approved I-539 found during I-485 preparation be corrected under 245K without misrepresentation? The I-539 was approved, but the error was discovered probably after. Well, I-539, I want to assume that is either an extension or a change of non-immigrant status. What I will advise that you do in this case to prevent misrepresentation, if you are completing I-485, I want you to prepare a sworn affidavit and explain that this is the error in your I-539 application. The error was unintended. You did not find out about the error until now. And when you found out, you immediately decided to execute this affidavit. So you should prepare that sworn affidavit, attach it to the I-485. So in the I-485 itself, at the very last page where you are required to provide additional information, you write there, see attached affidavit. So that way, since you are the one that brought it up, not that USCIS has raised it, it should not be counted against you as misrepresentation.
Yeah, I think so, based on his wording.
Oh, USCIS discovered it. Oh, if USCIS discovered it,
The I-539 was approved, but the error was discovered.
Yeah.
yeah, the error could have been discovered by him after approval. Because if USCIS discovered it, they probably would not approve it.
No, I think they discovered it later,
Yeah, it said
after approval.
the I-539 was approved, but the error was discovered.
He didn't say who discovered the error.
just
I think
makes
it
it
is
sound like
subject to
it's
both
there. Yes, you're right.
interpretations. So I'm going to say, if you are the one that discovered the error, the chances of not using it against you is extremely high. They are not going to be able to use it against you if you are the one that discovered the error and you provide this sworn affidavit. On the other hand, if they are the one that discovered it, well, you will still need the affidavit, but now whether they will use it against you becomes 50-50. Because it is one thing for them to now believe you, it is another thing for them to not believe you. So it becomes 50-50. But if you are the one that discovered the error yourself, I want to strongly believe that if USCIS was the one that discovered the error, they probably would not approve it.
Or they would have revoked it.
Yeah, they probably would not. So I assume that he is the one that discovered it.
Applicant discovered by the applicant after the approval 2 years later.
Yeah, so he's the one that discovered it. So yeah, so just do the sworn affidavit and attach it to the I-485. And at the last page of the I-485, where they require additional information, write there, see attached affidavit. So that way they will not use it against you. Next question. Okay, one of two. He went inside. Are you sure this is the beginning? Okay, let me continue. He went inside, then came back and told my cousin that the divorce certificate is fake. However, my cousin insists that the document is genuine because the case number appears on the Lagos State government website. What do you think might have happened? It was supposed to be one of two. Where is two?
I don't see two. I only see 1 and 2. 1 and 3.
Yeah, I think there's probably one because look at the
It's not posted. Maybe he thinks he sent it, but it's not on the chat.
yeah, because the question is not complete.
It's not. It looks like an officer took the document and then they realized that the divorce certificate is fake. But I don't know what the situation was.
Yeah, but if it is showing as valid on the legal what?
Do you see another one?
Good eye. This is from a different.
No, this
Yeah, from a different.
should be this logo.
Well, no, I know. I was looking at the channel activity, but I saw these ones, but that's from an old one.
Okay.
Yeah, never mind.
Okay. If it is showing on the Lagos State portal, Lagos State Judiciary portal, and everything there is valid, then I don't see.
Matches. And everything matches.
Yeah, that's why I say everything is valid because it is one thing for it to show on the portal. It is another thing for the information on the portal to be the same as the information in the document that was presented. For example, the portal may have a different case number. There may be other slight differences between what was submitted and what is on the portal. But assuming that what was submitted is what is on the portal, I don't see how USCIS can validly reject it. So, what I will advise you to do, depending on whether you have an attorney or not, print out the page from the Lagos State Judiciary. Submit it immediately. Don't let it be. I mean, if this happened today, I will probably do it today, so that it will be clear that this is not an afterthought. This is not something that was done after. This is something that was contemporaneously done. It was done simultaneously, instantaneously. So it's not that you have time to go and correct anything. So print it out, let it show the date, and then even if they didn't issue any request for evidence of anything, submit it and let them know that no, your divorce is valid. But before you do that, you have to check yourself the information in the document that was submitted and the information in the online document. For example, personally, I have attended to a client before who brought a divorce document from Nigeria. So when I check it on the Lagos State Judiciary myself in my office, the document showed up there. But as I was reviewing it, I also noticed that the document that was posted on the Lagos State Judiciary actually stated suspected fraud. It was part of the document. So, if something like that is what is shown on the website, definitely your case is probably going to be denied on that ground. So this is one of the reasons why it is always good to verify all these documents before it is submitted to the government. So before you raise any issue or concern, make sure you review it yourself. I've seen this before.
He said that it happened in Nigeria and not in the US. It's a fiancé visa.
Yeah, it is still the same thing. You know where I keep this document in that, please bring that bunch of documents. I can show them example of what I'm talking about. I've seen this before. So the mere fact that it shows on the Lagos State Judiciary does not mean it is valid. So there are a lot of issues that could have been discovered. So you have to be sure that the document is actually valid. So while waiting for Kim, can you go to the next question, please? Hello, doctor. Can someone with pending I-589 travel confidently within the U.S.? Someone with pending asylum was caught and placed in removal proceedings to pay the annual asylum fee.
That was one of three, right? That's not, I don't see any other question from him, but it did say one of three. No, sir, I don't see any other question from him.
Okay. So assuming that is the only question, the answer to the question depends on a number of factors. The simple answer to your question is yes. If you have a pending asylum application and you have employment authorization, for as long as your I believe that you should have either a state ID or a driver's license. For as long as your driver license or a state ID is real ID compliant, you will be able to travel without even showing any other thing. That will be enough for air travel within the United States. I am confident of that. On the other hand, if you don't have employment authorization, and if you don't have a real ID compliant,
You know what? He withdrew the question.
oh, okay,
He deleted it. So the next one will actually be this one, sir.
okay.
You want me to look for it for you?
You may not know what I'm looking for. Do you think you will? So, I was talking about the person who is asking question about traveling. So, if you do not have a state ID or real ID compliant driver license or a state ID, then traveling by air can actually create a problem for you. And of course, if you have received a letter or an email from USCIS asking you to pay the asylum fee after it was restored, initially there was a court order stopping it, but after it was restored, if you have received the letter and you didn't pay it, of course, some officers may use that as the basis to have you arrested. You want to show it? This is example of what I was talking about regarding divorce from Nigeria. Will it show? Will they see it? The highlighted part is where it shows suspected fraud.
Case.
Yeah.
And then,
Yeah, suspected fraud. Even though it shows up on the Lagos State Judiciary, as you can see clearly, it also indicated that it was a suspected fraud case. Is that fraud or fake?
fake case.
Yeah.
Fake case.
Suspected fake case. Yeah, suspected fake case. So, it is not enough to just say that the document shows up on the Lagos State Judiciary. So you have to review it. What does it say on the portal? It could say it is fraud. It could indicate that it is fake. I mean, all these things, we experience all these things, and that is why it is always good to patronize an experienced immigration attorney before you file or submit any document to the U.S. government. This example that I showed you, this was something I discovered while doing my own due diligence after the document was submitted by a client to me. So I decided to do my own due diligence, and then I found out that it actually states that it was suspected fake case. So you advise the client in such a situation, because the moment you submit it to the government, it doesn't matter whether it is at the embassy, at the CBP, or at USCIS, or even at the immigration court. Once a fake document is submitted to the US government, it becomes a case of misrepresentation and is a ground of inadmissibility. So a visa could be denied on that ground. A green card application could be denied on that ground. A change of status application could be denied on that ground. Adjustment application could be denied on that ground. Even asylum application could be denied on that ground. So that is that. Let's go to the next question. Good afternoon, sir. Please, how many days does it take to receive an adjudication after submitting an RFE for L1A visa for the country currently under the travel ban? Well, as you yourself already pointed out, 6 months. The ban is not for 6 months. The ban is to be reviewed in 6 months, and 6 months will be in June. So for now, under the travel ban proclamation, USCIS are forbidden from taking a decision on a case. So because we cannot predict accurately whether your country will be removed from the travel ban or not, even in the 6 months' time, it is difficult, if not impossible, to even give you any idea of how long the case is going to be. What I can tell you is that pre-ban, before the ban, usually once an RFE is submitted, USCIS have 60 to 90 days to review it and take a decision, even though sometimes they go beyond that, but that is the average. That is the average. But with the travel ban, we can't even have any clue as to when this will be, because it is not even certain that a particular country will be removed in the 180 days time, which is 6 months. So we don't know yet. So it's a lot of guesswork. Go ahead to the next question, please. Next question, please. Maybe I'm Nigerian and I just renewed my I-551 stamp based on a pending 751. Although I've traveled several times on I-551 stamp, I wanted to find out if it is advisable to travel with it now. So if it is if this person, he said I'm Nigerian, so already, yes, you can travel with it now if you still have a valid one, because it does not affect anything that somebody already have. What the travel ban affects is a pending application that has not been approved. Now, in your case, it means that you have a pending removal of condition, which is what 751 is all about. So that is what the stamp means. The 551 stamp simply means that you have a pending application for extension of your removal of condition, and based on that application that is pending, they are stamping your passport to allow you to continue to work and to continue to travel. So for as long as that stamp is not expired, yes, you can continue to travel. You can continue to use it. The travel ban will not affect you. However, if the stamp is expired, it may be difficult for you to renew it. In fact, I have somebody right now whose 751 stamp expired. This person scheduled an InfoPass appointment to get the new stamp. But for some reason, USCIS informed this person that because he is from the travel ban, one of the travel ban countries, they declined to stamp the passport. And subsequently, I don't know what happened, this person was arrested and picked up by immigration, because now, technically, it doesn't have a valid status, even though the 751 is pending, but the stamp is expired. In my opinion, he is still a permanent resident because the 751 is yet to be denied, so it is still pending. But this person was arrested and placed in custody. In fact, I've just filed a writ of habeas corpus on this person yesterday in this office because I believe that this person was illegally arrested and detained. So, in your case, for as long as the I-551 stamp is still valid, yes, you can travel with it, but make sure that you come back in before the expiration of that stamp. Otherwise, you may face some challenges because if you get stuck out of the country, usually it will have been easier for you to get what is called travel foil at the embassy. But based on the travel ban, I'm sure no embassy will give anyone from a travel ban country any travel foil. So my advice, you can use it to travel, but you need to come back in before the expiration of the stamp. Okay, does bankruptcy affect 751 application, especially if SBA loan is involved? No, it does not affect it. However, it may affect citizenship because citizenship has a requirement that has to do with good moral character. But 751 is just a removal of condition. In fact, there are only two scenarios where somebody may need to file 751. If you obtain a conditional permanent resident based on marriage to a U.S. citizen, you will be required to remove that condition within 2 years from the date of the grant of the conditional permanent resident. That is one scenario. The second scenario is if you are an investor, if you invest $800,000 in the U.S. and you get a conditional green card based on an approved I-526, then you will need to also remove condition by filing I-829 at the end of 2 years, or maybe you can submit the application 3 months before the expiration. So those are the only two scenarios where you are required to file I-751. So for that reason, it has nothing to do with your bankruptcy. If it is based on marriage, what you need to prove is that you and your U.S. citizen spouse, you are still living together as husband and wife. And even where you are no longer living together, if you are eligible for a waiver, you can still file self-petition based on good faith marriage and still get it approved. It has nothing to do with bankruptcy. On the other hand, for the investors, what you need to prove to get the removal of condition approved is that your investment actually created employment as indicated in your I-526 application. So because for that program, every investor must show that his or her investment created at least 10 American jobs. That is all you need to prove. So it doesn't have anything to do with bankruptcy. However, for citizenship purpose, citizenship has a requirement of good moral character. So if you are owing SBA, especially if you have defaulted, that will serve as evidence of lack of good moral character. I've seen people who owe IRS taxes being denied citizenship because USCIS believe that they lack good moral character. I've seen people being denied because they were accused of being a drunkard, even though they have never been convicted of any drunk-related offenses. You know, when it comes to good moral character, you don't have to have been convicted of any offense. USCIS has this wide power to determine what constitutes good moral character and what does not. And let me shock you. I remember during my own citizenship, the day we were being sworn in, we were told on that day that if you are driving on the road and you see a fellow American on the roadside, maybe the car had an issue or something, you are required to stop and offer help. If you don't, that could be counted as evidence of lack of good moral character. And like I said, this good moral character thing, the power, USCIS power is so wide that it is extremely difficult to exhaust. So I'm just going to tell you, if you are actually owing SBA, for the purpose of the 751, it may not affect it, but I will advise you to put your house in order before you get to citizenship state. Otherwise, it could be denied. Next question, please.
He just commented that he got the stamp 3 weeks ago.
Oh, okay, so that will still be valid. Yeah, that will still be valid. You can travel. Next question, please.
It's on the screen.
Okay. Good afternoon, sir. Can one file I-140 and 485 concurrently since the visa bulletin for EB3 is current for most countries? Can bank countries still file? Yes, you can still submit your application if visa is current. What?
It's not current right now.
Well, the question says it's current, so I'm only answering the question. So if it is current, yes, you can file. But I'm being told here that EB3 is not current, so you may want to check very well. But if it is current, the answer is yes, you can still file. The ban is only saying that USCIS should not adjudicate. It didn't say they should not accept applications. And in fact, since the ban took effect in January, we have been filing applications and we are getting receipt notices and all of that. The only thing they are not doing is to adjudicate the applications and petitions. But yes, you can still file concurrently if visa is current. You need to check the visa bulletin because there are two categories. There is a different section for people who are outside the United States, and there is a different section for people who are applying from the United States, and the visa bulletin dates are different. So make sure you are checking the correct date, because I have been told here that EB3 is not current right now. So even for visa application and adjustment. Okay, but I'm still answering the question. If visa is current, you can apply concurrently, but you have to be sure it is current. Next question, please. I had a pending employment application, but had to file for asylum and for withholding of removal last year due to fear. Can you advise if I should apply for the employment authorization? Well, the issue is somebody who is already on the floor need not be afraid of falling. You already apply for asylum, whether or not you are eligible, it is immaterial. So if you are eligible for employment authorization, you can as well just apply. So my answer will not affect your asylum one way or the other. But if you are eligible for employment authorization, go ahead and apply. Next question. Okay. I filed for VAWA with work authorization December 2022. Got request for more evidence in April 2023. I think I answered this question at the beginning. Yeah. But I'm yet to receive anything on work authorization and no progress on VAWA too. Any suggestion? I answered this question before, but I'm just going to repeat it. Yes. The issue here is that we need to understand what VAWA is all about and what employment authorization is all about. Okay. Employment authorization is not attached to VAWA. VAWA is filed using Form I-360. She sent a follow-up about it. Okay. So it is only when the VAWA is approved that employment authorization will be approved along with it. So if you want to get an employment authorization while your VAWA is pending, you will need to submit Form I-485, application for adjustment of status. It is I-485 that employment authorization is attached to. You will now submit Form I-765, which is application for employment authorization, and your category will be C9. C9 means you have a pending application for adjustment. But if all you have is your VAWA, then you will not be getting employment authorization anytime soon.
Okay, she said she found I-765 and I-45. While I got no response on the I-765, the response on the I-45 says I've got it through other means.
Got which one now? Got 765 through other means or I-485 through other means?
No, the response, you see the last message there.
This one, I filed for I-765 and I-485 while I got no response on I-765, the response on I-485 says, I've got it through other means. Thank you, sir. I still don't understand the question. One thing I know is that if the I-765 is properly filed, you will get a receipt notice. So the question is, have you ever received a receipt notice? So without a receipt notice, you don't have anything pending. So it may be that your application has been rejected. So you may want to check your mail. If you don't have a receipt notice for the I-765, it simply means that USCIS did not accept it. If it was accepted, you will have received a receipt notice. That is evidence that you have something pending. So if you do not have a receipt notice, you don't have anything pending. It may have been rejected. Then the issue of getting it through other means, well, that one, I really don't understand it. Did you file any other application? Because if you submitted multiple applications for adjustment of status, if one is approved and the other one is pending, that is the scenario where we get that kind of letter from USCIS. But if you have never filed anything else, maybe you will need to call or send a letter to USCIS telling them that you do not have any other application pending. The truth of the matter is that USCIS sometimes make mistakes. I mean, we have seen that before. They may have mixed up your alien number with another person. They may have missed one number or something from it, and it will have pulled up another person's file, making them think that you have received adjustment of status through other means. So you have to respond to them if there is no other application that you filed.
I just got updated information for April. EB3 is current.
Oh, EB3 is current.
April.
For April.
Yeah.
Yeah, that's the most current one. Okay.
I was going off March, so that's.
Okay. For the person who asked the question about EB3, I've just been informed now that EB3 is actually current, so you may be right. So if I know, maybe you are right. For April, it is current. Yeah. It is current for April. Yeah. Next question, please. Good afternoon, sir, and team. Thank you. Good afternoon. I'm an F1 student, almost at the end of my STEM OPT, with approved I-140, done biometrics and fingerprint, but EAD and green card is still being processed. Please, what happens after OPT? After OPT end? Good question. Without getting the EAD or GC as I'm from Nigeria. Good question. The truth of the matter is that there are two issues here. One is maintaining legal status. The other one is ability to work. The fact that you have your I-485 submitted before the expiration of your F1 status or before the expiration of your OPT, that means that you are legally present in the US. You have legal status in the US. However, the other issue is employment. Even though you are legal in the US, are you authorized to work? Not yet. So you have to wait for the I-765 to be approved. However, let me say this. If you are currently working for an employer, I've stated this multiple times, and I think I mentioned it last week too. If you are currently working for an employer and you have the renewal of your employment authorization that is currently pending, you can legally continue to work for that employer for at least up to 10 months after the expiration of your STEM OPT. Legally, you can continue to work for them. However, if a decision is taken within that 10 months, if the application for employment authorization is denied, then you may not work for the employer. And of course, if it is approved, there is no more an issue. Problem solved. Next question, please. I came in with asylum. What does FTJ mean? I don't understand that. I'm just going to skip that. I came in with asylum last year, September. When can I file for my permanent residency? Oh, okay. If you enter the United States as an asylee, you have to wait 1 year. 1 year after your entry. So if you came in September last year, you can submit application for adjustment of status by September of this year. So you are only required to wait 1 year before submitting application for adjustment of status. Next question. Thank you, sir, and team. I appreciate your response. You're welcome. Next one. You skip one now, did?
That was ours.
Oh, okay. This one, okay.
Yes, it was ours.
Okay. Next question. Permanent green card. I-130 was submitted February 2022 and was approved April 2025 for my child who will be 21 in June. We already submitted I-485 and did biometrics here. What happens when it turns 21? There is one question that there is one pertinent point that this question omitted. And that question is, at the time the I-485 was submitted, was this child maintaining legal status? Because this is one of the major differences between a U.S. citizen and a permanent resident. When a permanent resident is sponsoring an applicant for adjustment of status, that beneficiary must be maintaining legal status from the date of entry into the United States until the date the adjustment application is submitted. So, since this question is not clear as to whether this person was maintaining legal status, so I'm going to answer it both ways.
He says, can I use I-45 receipt to apply for driver license in Texas from Nigeria?
That must be a different question.
But it's the same person.
Yeah, but let me deal with this one first.
Yes.
Because this is the kind of things that create problem for people, and that is why I want to make sure I explain these questions very well. Mm-hmm. Now, I'm going to answer it both ways. Assuming that the child is already out of status for 180 days or more before the adjustment application is filed, I can tell you for free that the adjustment application is going to be denied. On the other hand, assuming that this person was maintaining legal status at the time that the I-485 adjustment application was filed, or the child has been out of status for a period less than 180 days, then Child Status Protection Act will kick in. Only if visa is current at the time that the child turns 21. If visa is current at the time the child turns 21, Child Status Protection Act will kick in. But if visa is not current, then unfortunately the child will age out. The petition will change from immediate family to unmarried child of a permanent resident. Now, you said there's a second question.
He's asking this.
Can I use I-485 receipt to apply for driver license in Texas? No. In Texas, they will ask for employment authorization or the green card. The I-485 receipt only proves legal status, but at least in Texas, I know they will not give you employment authorization based on that. And they will not give you driver license based on that. Next question, please.
You said that you only wanted to go for an hour?
Yeah, I just realized that we've been on for more than 1 hour.
Just wanted to let you know.
Well, okay. We cut it off at 1:30, so just determine how many more questions to answer before we go. You can see my nose is running, but at the same time, I want to answer as many questions as possible. At least to make up for the period that we didn't go online. Okay, just tell me once it is close to 1:30, we just end it. That means we have 15 more minutes. Okay, next question. Hello, Dr. Asekun. Sorry about your cold situation, sir. Thank you. I'm from Nigeria. My I-485 priority date is current now. Does the pause affect people in the US? Yes, it does, but it doesn't prevent you from submitting your application. So if your visa is current, go ahead and submit it. USCIS will accept it. They will issue receipt notice. They will ask you to go for fingerprinting. You will do all of that, and then they will hold on to it. The only thing they cannot do is to adjudicate it, but they will still accept it. Go ahead and submit it, because you know that visa bulletin fluctuates. Now that it is current, you better submit it, because if by next month, if it retrogresses, you may no longer be able to submit it. So if you have the window now, if the window is open, just go ahead and submit your application. That would be my advice. Next question, please. Good afternoon, Dr. Olu. Oh, he moved.
I'm sorry.
Yeah. Good afternoon, Dr. Olu. You are indeed a blessed man. Amen. Thank you.
This is from the same person.
Okay. No, I can't see it. Move it lower a bit.
No, it's this one. That one. After the submission of
Oh, okay. After the submission of I-485 and 765, what are the necessary information to expect from USCIS? If you are from the visa banned countries, once you submit it, you will get receipt notice. So once you submit it, like I said, you get receipt notice. After that, you get fingerprinting notice. After that, then it becomes a waiting game. We wait until June to see if the visa ban will be revised and if your home country will be removed from the list. If it is removed from the list, you will be able to, USCIS will be able to adjudicate the adjustment application. But if it is not removed from the list, then the waiting game continues. Okay, good day, doctor and Cruz. Good day. Please, doctor, stop taking cold or high substance for now. Take something warm that your body system don't need cold substance. Thank you so much. Thank you.
She said that too.
It is well with you, with your soul, spirit, and body. Keep fit. Thank you. Thank you so much. Okay. Okay, next one. What is the government saying about cases that are pretermit to third world countries? Oh, I think I addressed this last week. There is a court order. There is actually a court order that a federal judge ruled that it is illegal for the Trump administration to deport people to a third country. So there is a court order that has stopped that. So if you are in that situation, if you have already been ordered removed, go ahead and file a motion to reopen. If your case is still pending, let your lawyer know about the case. I think I mentioned the case last week. I can't remember the citation in my head right now. But I think I can't remember. You may need to look at some of her. But if you have an immigration lawyer, once you tell your lawyer that there is a court order that declare the Trump administration's policy of removing people to third countries illegal, your lawyer should be able to find it. So that should not be a problem. And if you don't have a lawyer, go on Google yourself, Google it and see. You should be able to find it. I can't remember the case on top of my head now, but I remember I mentioned it either last week or before then. Oh, you have the case?
I'm looking.
Oh, okay. Please go to the next question. If we find the case, we will let you know before we leave. Thanks, doctor. Please, with the new April 2026 visa bulletin with final action July 2022, can I on religious visa EB4 with priority date of October 2021 the thing moved again. Be hopeful to receive adjustment to green card soon. How soon? Oh yes, visa, the EB4, I mentioned it last week that the EB4 category moved. It actually moved substantially. If I recollect correctly, it moved to 2023 from 2019. It jumped like 4 years. So, but as to when you will receive the green card, that depends on whether or not you are from the travel ban countries, because the travel bans will still affect your case if you are from one of those travel ban countries. So just pray that by June, when they review it, your country will be removed from that list. That is assuming you are from the travel ban countries. Assuming you are not from that country, you should be getting your green card within the next 60 days. If you don't, in fact, if I were you right now, I won't even wait. I will do a service request, and I will also use congressional intervention since it is current. But that is assuming you are not from the travel ban countries. If you are from the travel ban, one of the travel ban countries, you just have to wait until that issue is resolved. Next question, please. We have 9 more minutes to go. Good afternoon. Got a mail notification from USCIS via informed delivery from post office, but mail not found. What do I do?
You know, the post office normally notifies.
Yes, you have to. Well, I don't know how long ago you got this the notification, but you have to contact the post office. The truth of the matter is that the United States Postal Service, they are not allowed, they are not permitted to forward immigration documents. So if you have moved and you have not done a change of address with USCIS, informed delivery will not solve the situation. Informed delivery has actually done its work in this case by notifying you that there was a document coming. But they are not going to keep that document for you, because by regulation, the United States Postal Service, they are required to return the document to USCIS if your address have changed and you have not done a change of address with USCIS. By law, everyone who is not a US citizen is required to notify USCIS or immigration court or ICE, depending on what stage your case is, if your address changes. So if you have moved, you need to do a change of address. If you didn't do it, the informed delivery is not going to solve that problem. So that may be the reason you didn't get the letter. It may have been returned. But if you contact the post office, I'm sure they will tell you. Next question, please. Good afternoon, sir. Please, if you have a pending case and your petitioner is very sick while living in USA, can you expedite the case with a medical reason due to she needs help? Oh yes, that is possible. You can request for expedited processing based on the petitioner's health condition. However, I cannot tell you authoritatively right now, based on the travel ban. If you are from one of the travel ban countries, I cannot tell you authoritatively whether or not your expedited request will be granted, because everything is being affected by the travel ban. But if you are not from the travel ban countries, oh yes, that is the exact situation that expedite request is required to address. Yes, you can do that. Just obtain the medical record and submit it along with your request for expedited action on your case, assuming you are not from the travel ban countries, one of the travel ban countries. Next question, please. Stay strong, doctor. You are healed in Jesus' name. Amen. Thank you. Thank you. Thanks, sir, for your work for the immigration community. As promised last week, have you been able to get any update for people from the ban countries who want to join the military? Oh, yes, I did. I actually have somebody in this office who went to one of the recruitment centers, and the person was told that, yes, they can still be admitted into the military. Can you please help me call for me? I want to verify the aspect of the citizenship. I can't remember. I know she gave me the report yesterday. Can you please refresh my memory about your finding yesterday regarding the admission of people from travel ban countries into the military?
Okay. Sergeant I met with yesterday said he has not heard anything like that.
that they continue to admit them.
They still admit them, and that he has not heard anything. And although I did not ask with regards to them getting citizenship, but he said they don't have any. There is no problem.
There's no instruction that they should not. Okay. Yeah, the finding is that they are, at least so far, based on the local inquiries we made here in Dallas, the information is that they are still admitting people from the travel ban countries into the military. So I believe if you are planning to join, you can still go ahead and join. Next question. Greetings, sir. My I-140 for EB3 visa was approved recently. My priority date is current, but I have not yet received NVC to pay the visa fee. I'm from the 75 visa post countries. Shall I go for my interview? This person is probably mixing things up. So I want, from the way this person is talking, I believe that this is a visa, this person is outside the country, because NVC only deals with people from outside the countries.
But if she has not paid the fee, how is she going to go to an interview?
No, it has not even gotten to the interview stage. That is what I want to explain, is that if this person is outside the country, let me explain the procedure. For people who are applying for adjustment of status or applying for immigrant visas from outside the country, they first have to deal with the National Visa Center. Once the priority date is current, the National Visa Center will send you an invoice and you will pay the immigrant visa fee. So once the immigrant visa fee is paid, subsequently, the National Visa Center will ask you to create an online account in their portal where you will be able to submit documents and submit applications. You will then submit immigrant visa application. You will also submit police clearance certificate. You will submit a copy of biometric page of your passport. You will submit all the required documentations to the National Visa Center. The National Visa Center will review it. If everything is okay, they will send you an email telling you that your case is documentarily qualified. So once you receive that email, it is only after that that the NVC will contact the embassy in your home country and request an appointment, an immigrant visa appointment. So until you get the immigrant visa appointment, you can't even do anything further. Once you get the immigrant visa appointment, at that stage, you now need to do medical examination. The embassy of your country, every embassy have designated medical centers where they are allowed to perform medical examination for immigrant visa applicants. So you will do the immigrant visa medical examination and then attend your interview. Now, interview may be twice. They may ask you to come in for document review first, and then subsequently, you will now go for the real interview. So once approved, they will issue you immigrant visa, and you will have 180 days from the date of issue to travel to the US. So that is the way it works. So based on the information you have provided, you are not even getting to the stage of interview yet. So the first thing is to pay the immigrant visa fee. If you have not received immigrant visa fee invoice from NVC, my advice to you will be to do an inquiry. You do an online inquiry with the National Visa Center. It is possible that they may have sent you this invoice a long time ago. Maybe while you are waiting for visa to be current, maybe they already sent you the invoice. You didn't pay it. But go back and check your email. Check with your case number. If you know your case number, search your email with your case number. If they have sent you the invoice previously, you will see it there. But if they have not, contact the NVC through the online inquiry and request an invoice, because without the invoice, you cannot pay the fee, because they will give you invoice ID and you will need that to log in order to make the payment. So that is the process. So it's 1:30. The next one should be my last question for the day.
And the case is DVD et al. VDHS.
I didn't get
The
you.
one you had asked me to look up.
Uh-huh.
It's DVD, like the initials DVD, and then et al. Versus the Department of Homeland Security.
Oh, the case. Oh, okay. Yeah. The case that we were talking about regarding deportation of people to countries they are not from. So that case is, can you call it again?
DVD.
D as in David, V as in Victor, D as in David, DVD versus the Department of Homeland Security. So that is the case. So the court has declared that it is illegal for the Trump administration to deport people to countries they are not from, to a third country. So just tell your lawyer, if you have already been ordered removed, you can go ahead and file a motion to reopen. If your case is still pending, make sure you notify your lawyer so that you are not deported to a third country even after the court has declared this to be illegal. So, that's the last one for the day. Okay. Now, this will be the last question for today. Keep up the good work, doctor, and your team. Thank you. My citizen son submitted I-130 for me and his dad since April 2025. Will it be approved or dismissed, as we have not had anything from USCIS? Well, unfortunately, this person didn't indicate whether you are from one of the travel ban countries. If you are from one of the travel ban countries, you have to wait for now, because USCIS is not permitted to. Also, do I wait to receive approval before filing for green card? Oh, is it the same person? Oh, that was an error. If your son file I-130 on your behalf, if you are physically present in the US and you enter the US legally with a visa, you can actually submit the I-485 application for green card without waiting for the approval of the I-130. You are eligible to apply concurrently for as long as you enter the US legally with a visa. You can apply concurrently. And as I said before, if you are from one of the travel ban countries, USCIS may not be able to approve your I-130 at this time until that ban is lifted. But go ahead and submit the I-485 so that whenever the ban is lifted, you can just get your green card. Don't wait for the approval of the I-130, because if you file concurrently, both of them could be approved about the same time. So we will end the podcast for this week today at this time. Remember to join us on all of our social media platforms. Join us on Instagram, TikTok, X, Facebook, and YouTube. And remember, stay safe and keep yourself out of trouble. I remain yours sincerely, Dr. Olu Asekun. I hope to see you next week, if God tarries. Thank you, and God bless you.